Hello everyone, welcome to Learn Law with AKP. In today's class, we are going to discuss an important topic under contract of bailment, kinds of bailment. In previous classes, we understood definition of bailment, essential requisites of bailment. Now, we will understand the different types of bailment recognized under law. This is an important exam topic because students are often asked to difference between different kinds of bailment. So, let's begin. Kinds of bailment means different categories of bailment. Generally, bailment is classified based on whether payment or reward exists and who receives benefit. The two main kinds are gratuitous bailment, non-gratuitous bailment. Now, let us understand each one clearly. First is gratuitous bailment. Gratuitous means free of cost. In gratuitous bailment, no payment or reward is involved. For example, suppose you lend your laptop to your friend for temporary use without charging any money. This becomes gratuitous bailment. Here, you are a bailer, friend is bailee, no consideration exists. This is bailment without reward. Now, let us understand the important features of gratuitous bailment. First, no consideration or payment. Second, goods are temporarily delivered. Third, goods must be returned after purpose completes. For example, giving books to a friend for study purposes without charging money. This is a simple example of gratuitous bailment. Now, let us understand non-gratuitous bailment. In this type, payment or reward exists. Either bailer or bailee receives benefit. For example, giving your bike to a mechanic for a repair after paying service charges. This is non-gratuitous bailment because payment exists. Most commercial bailments fall under this category. Now, the important features of non-gratuitous bailment is: first one, consideration exists. Second, usually commercial in nature. Third, both parties receive benefit. For example, dry cleaning services. Customer receives cleaned clothes. Dry cleaner receives payment. So, both parties benefit. Now, let us compare the two kinds of bailment. In gratuitous bailment, no payment exists. In non-gratuitous bailment, payment or reward exists. Gratuitous bailment is usually personal or friendly. Non-gratuitous bailment is usually commercial. For example, friend borrowing laptop is gratuitous. Repair shop repairing laptop for charges is non-gratuitous. This difference is very important for exams. Now, let us understand an important case law. In Coggs versus Bernard, a person voluntarily agreed to transport barrels without payment. During transportation, the barrels were damaged due to negligence. The court held that even though the service was free, responsibility still existed. So, here the principle established, even gratuitous bailies must take responsible or reasonable care of goods. This is a landmark case in bailment law. Now, let us quickly revise. Kinds of bailment are gratuitous bailment, non-gratuitous bailment. Gratuitous means free of cost. Non-gratuitous means payment exists. In both cases, goods are temporarily delivered and must be returned later. Let's conclude this topic. Kinds of bailment mainly include gratuitous and non-gratuitous bailment. The main difference depends on whether consideration or reward exists. We also understood that even free services create legal responsibility through the important case of Coggs versus Bernard. So remember, free or paid, responsibility exists in bailment. For exams, always remember definitions, differences, examples, and case law. Thank you. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.